Have you ever heard of right to promotion being the fundamental right of a country? Or right to be fairly considered for a promotion being a fundamental right of a country? You'll see this in recent Punjab and Haryana High Court judgment. See, a recent Punjab and Haryana High Court judgment has reaffirmed that while government employees they do not have a guaranteed right to promotion, but they do have a fundamental right to be fairly considered for promotion if they meet eligibility criteria. Now, this particular ruling highlights an important constitutional principle in public employment. Authorities must ensure fair, timely, and a non arbitrary evaluation of eligible candidates. Now, the case also shows how this right is often violated in practice, bringing attention to the gaps between legal safeguards and actual implementation. Which is why today we will be discussing about the right to be fairly considered for promotion. And also, we'll be discussing in detail about Article 14 of our Indian Constitution. Hello, my name is Kulwant Singh, and you're watching Perspective. Now, let us start with the background of the case. Now, this case is a case of denial of promotion consideration. Now, Shri Kulwant Singh, a junior engineer, approached the court after being excluded from a Departmental Promotion Committee which evaluates candidates for promotion. Now, the government claimed he was ineligible due to a distance learning diploma. However, the High Court found that the government had misinterpreted its own amended rules, which exempted existing employees like Singh from this recruitment. As a result, his case was never considered by the DPC. The court held that this amounted to a violation of his fundamental right to be considered for promotion. The court also directed the government to grant him a national promotion with a retrospective effect and mandated that DPC meetings be held every 3 months. Now, what is the constitutional basis of this particular right? See, the right to be considered for promotion is rooted in Article 14 and 16, Section 1 of Indian Constitution, which guarantees equality before law and equal opportunity in public employment. Now, courts have interpreted employment broadly to include not just entry into service, but also career progression, making fair consideration for promotion a constitutional requirement. See, what is the distinction between consideration and promotion? See, the Honorable Supreme Court of India has clarified in the year 1991 Lift Irrigation Corporation case that there is no fundamental right to promotion itself. However, every eligible employee has a right to be considered for promotion in accordance with the applicable rules whenever a vacancy arises. Now, judicial reinforcement of the principle can be seen in our country, which is why this principle was reaffirmed by a 5-judge bench, Constitution bench in the year 1999 in Ajit Singh versus State of Punjab case. The court held that any employee who meets eligibility criteria and falls within the zone of consideration has a fundamental right to be considered for promotion. Now, the court further clarified that if an eligible employee is not considered for promotion, it amounts to a clear violation of their fundamental right, as this right is a personal and enforceable constitutional guarantee. Now, since we have understood about the case, let us understand about the judicial interpretation in practice of this particular thing. See, the application of the right to be considered for promotion has been consistently shaped by the court rulings in our country. In July 2024, Bihar State Electricity Board versus Dharmedeo Das, the Supreme Court reaffirmed that while the right is fundamental, there is no vested right to promotion from the exact date a vacancy arises in our country. The court rejected a claim for backdated promotion, noting that administrative delays can justify deviations. High Court have increasingly invoked this principle to address delays in holding Departmental Promotion Committee (DPC) meetings, which often stalls career progression in our country. Now, the courts have recognized that prolonged inaction can effectively deny employees their fundamental rights, which is why key High Court's intervention can be seen in multiple instances. In December of 2025, the Himachal Pradesh High Court directed the state to expedite its DPC proceedings for senior lecturers nearing retirement, emphasizing that this right cannot be defeated by unnecessary delays. And similarly, in the year 2022, the Manipur High Court, it granted national promotions to police inspectors who were eligible since 2007, but they were promoted only in 2021, acknowledging the loss of career advancement due to the state inaction. Also, the Delhi High Court in 2024 stressed the importance of regularly convening DPCs to ensure eligible employees are considered on time, and it highlighted that delays not only harm employees but can also affect administrative efficiency in our country. Now, since this right to be treated fairly for promotion is a fundamental right and we are clear about this particular right and the case as well, let us try to look at fundamental right from a broader perspective. And then very specifically look at Article 14 of our Indian Constitution. See, the fundamental rights are enshrined in Part 3 of the Constitution from Article 12 to Article 35. And Part 3 of the Constitution is also described as the Magna Carta of India. Now, Magna Carta was a charter of rights issued by King John of England in 1215, and it was the first written document relating to the fundamental rights of citizens. Now, when we talk about the fundamental rights, the Constitution of India provides for 6 fundamental rights broadly. The first one is right to equality, that is Article 14 to Article 18. Right to freedom is the second one from Article 19 to 22. See, the third one is the right against exploitation from Article 23 to 24. The fourth one is right to freedom of religion, that is Article 25 to 28. The fifth one is cultural and educational rights, Article 29 and 30. And the sixth one is the right to constitutional remedies, Article 32 of our Indian Constitution. Now, originally, the Constitution also included right to property, which is Article 31. However, it was deleted from the list of fundamental rights by the 44th Amendment Act of 1978. See, this Article 31, which was earlier a fundamental right, was eventually made a legal right under Article 300A in Part 12 of our Indian Constitution, which is why these fundamental rights are very fundamental to the core of Indian Constitution and polity. Now, let us very quickly glance through the features of fundamental right in our Constitution. See, they are protected by the Constitution for sure, and fundamental rights, unlike any ordinary legal rights, are protected and guaranteed by the Constitution of the country itself. And some of the rights are available only to the citizens, while others are available to all the people, whether citizens, foreigners, or legal persons like corporations or companies. One more important thing is that fundamental rights are not sacrosanct. So they're not sacrosanct or permanent, and the parliament can curtail or repeal them, but only by a constitutional amendment act. Also, one more important thing is that these rights are not absolute but qualified in nature, which means states can impose at certain times reasonable restrictions on them. However, the reasonability of the restriction is decided by the courts in our country. And one more important thing is that these rights are justiciable. The rights are justiciable and allows persons to move courts for their enforcement as well, if and when they are violated in any way or manner. And any aggrieved person can directly go to the Supreme Court in case of a violation of a fundamental right, and they can get redressal. Now, the rights can also be suspended during the operation of a national emergency, except the rights guaranteed by Article 20 and 21 of our Indian Constitution. And further, the 6 rights guaranteed by Article 19 can be suspended only when there is an external emergency war or external aggression, and not on the ground of armed rebellion. A very, very important part, because armed rebellion is internal emergency, not external one. And also the application of fundamental rights to the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous service can be restricted or abrogated by the Parliament under Article 33 of our Indian Constitution. And also their applications can be restricted while martial law is in place. And martial law is nothing but a rule imposed under abnormal circumstances by the military. If martial law is in force in any area, this article can't be enforced. See, now since we have discussed a lot in detail about the fundamental rights, let us discuss about the one which is mentioned in this particular case. And that is your Article 14 of our Indian Constitution. Now, Article 14 says that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. Now, it uses 2 expressions. One is equality before law, and second is equal protection of the law. So basically, now we have 2 equalities, that is equality before law and equal protection of the law. And it confers this particular article rights on all the persons, whether citizens or foreigners. Now, equality before law and absolute equality, what do you mean by that? See, the concept of equality does not mean absolute equality, especially amongst the human beings, which is physically not possible at all to achieve. And it is a concept implying absence of any special privilege by reason of birth, creed, or like in favor of any individual, and also the equal subject of all individuals and classes to the ordinary law of the land. See, let us understand this equality before law and equal protection of law one by one. See, when we talk about equality before law, it is of British origin and is a negative concept which states that the law should be equal and should be equally administered, and that the like should be treated like. And it connotes the absence of any special privileges in favor of any person, the equal subjection of all people or all persons to the ordinary law of the land administered by ordinary law courts. And no person, whether rich or poor, higher law official or non-official, is above the law. Now, there is a concept of rule of law as well. The concept of equality before law is an element of the concept of rule of law. The concept was given by Professor Dicey in England. And it guarantees equality before the law. See, it requires no person shall be subjected to harsh, uncivilized, or discriminatory treatments. See, this concept is having three elements or aspects. First one is absence of arbitrary power or supremacy of law. It means that absolute supremacy of law as opposed to the arbitrary power of the government. It means that no man can be punished except for a breach of law. Again, a very, very important part. And then we come to the equality before the law. It means equal subjection of all citizens, rich or poor, high or low, official, non-official, to the ordinary law of the land administered by the ordinary law courts. See, the primacy of rights of an individual. It means that the constitution is the result of the rights of the individual as defined and enforced by the court of law, rather than the constitution being the source of individual rights. Now, this is the concept of equality before law. Now, I told you there is a second phase as well, that is equal protection of the laws. Now, it is a positive concept of equality. It is taken from the American Constitution and it connotes that the equality of treatment under equal circumstances should be there, both in the privileges conferred and liabilities imposed by the law. Now, it simply means the similar application of the same laws to all persons who are similarly situated. The like should be treated alike without any discrimination. See, the protection of Article 14, it extends to citizens and non-citizens both. The word any person in Article 14 of the Constitution denotes that the guarantee of equal protection of laws is available to any person, which includes any company or association or body of individuals. See, the protection of Article 14, it extends to both citizens and non-citizens and to natural as well as legal persons as well, which is why this is the entire concept of right to be fairly treated for promotion, right to equality, equality before law, and equal opportunity. See, now since we have understood about equal protection of law, equality before law, we've understood about this right to be fairly treated or fairly considered for promotion purposes, and we've discussed about all these things in a very detailed manner. Now, there is one doctrine which I want to discuss about in this particular session, and that is a doctrine of legitimate expectation. See, legitimate expectation means that a person may have a reasonable expectation of being treated in a certain way by administrative authorities, owing to some consistent practice in the past or express promise made by the concerned authority. According to the doctrine, a public authority can be made accountable in lieu of legitimate expectation. Thus, the doctrine of legitimate expectation pertains to a relationship between an individual and public authority, which the claimant can continue responsibly. See, understand one very important thing. Legitimate expectation may arise if there is an express promise given by a public authority, or because of the existence of a regular practice which the claimant can reasonably expect to continue. Such an expectation must be reasonable. Now, in Vishakha versus the state of Rajasthan, the Supreme Court laid down exhaustive guidelines to prevent sexual harassment of working women in the place of their work until the enactment of a legislation for this particular purpose. Now, under this, the court observed that the fundamental rights under Article 14, Section 2, Article 19, Section 3, Subsection 1, G, and Article 21, Section 4 of the Constitution of India, that every profession, trade, or occupation should provide a safe working environment to the employees. See, in Javed versus State of Haryana as well, validity of Section 175 subsection 1G of the Haryana Panchayati Raj Act of 1994 on the grounds that it will be violative of Article 14 of the Indian Constitution. See, Section 175 subsection 1G disqualified a person having more than 2 children from contesting elections for Sarpanch or Panch in Gram Panchayats, but did not apply to offices in other institutions of local self-governance or state legislatures or in parliament. See, the Honorable Supreme Court of India held that the provision is not discriminatory, and the classification made by the people on intelligible differentia having nexus with the object of popularization of family planning program. See, now we very clearly know by the end of this particular session that right to promotion is not a fundamental right, but right to be fairly considered for promotion is definitely a fundamental right under Article 14 and under Article 16, Section 1 of our Indian Constitution. Also, in detail, we have discussed a lot about fundamental rights of our country, its key features, its applicability, and also we discussed in detail about Article 14 of our Indian Constitution, one of its important doctrines. Now, I hope this entire concept is very clear in your brains, it is very clear in your minds. Now, do let me know in the comment section that should right to be promoted be a fundamental right in a country or not, especially India or not. I'll be very happy to read your comments. All the very best. Have a beautiful day, everyone. Thank you.